she said, his word against hers.
Christopher Melcher is a family law specialist.
Need to get to that point so quickly.
No way in California to keep it secret, and it's a nuclear option.
All rise. The Honorable Chief Justice and the Associate Justices of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court sitting on bunk is now in session.
Mr. Christopher C. Melcher.
Ready.
Calling the matter of In re Clifford Allen Brace Jr., Stephen Spire as trustee versus Clifford Allen Brace Jr. Mr. Melcher.
Thank you. The appellants confuse the way that spouses can hold title to assets with the character of that property. And Family Code Section 760 says that any property acquired by spouses during marriage is community unless a statute says otherwise. And to overcome that rule, we need to be shown a statute. And that's really the Valli decision, is just applying basic concepts of statutory construction and looking at the plain meaning of that statute. That's Valli. And here we're not pointed to any statute that characterizes joint tenancy property as community or separate. And when property is acquired by spouses during marriage in joint tenancy, it's community due to the time of acquisition. That's Family Code 760. And without a statute characterizing it as separate, the analysis really should end there. And the rules apply whether this is between spouses or creditors, because there is just one method of characterizing property, and I will address that in a bit. What Professor Blumberg is arguing is a completely different method of characterizing property, one that ignores 760. She takes the position that there can be community, separate, and joint tenancy, but there's no third dimension to characterization. Spouses either have community or separate property, and the way that they choose to title that, whether it's joint tenancy or some other form, doesn't change the character. It really makes no difference. And what's confusing folks here when they've looked at this is that right of survivorship as a feature of joint tenancy, thinking that it transforms that property into something else, but it doesn't. The rights of survivorship in joint tenancy property are meaningless until someone dies. During the life of the joint tenants, either one of them can unilaterally sever the joint tenancy and the right of survivorship. And so revocable rights of survivorship can't control characterization of property. The chance that one of them might die and end up leaving the entire estate to the survivor is a consequence of the right of survivorship. It's not a reflection of the underlying character of that asset. It's the same expectancy that we would have in a will or in a revocable trust, and we know that those things do not affect character. And what I think is really happening here is that people are confusing joint tenancy with a form of title that we did away with over 100 years ago, which is tenancy by the entirety. And under that scheme, both spouses would have to consent to the termination of the right of survivorship, and that form of title could only be held by spouses. But we don't have that. And so I think that's what got people confused a long, long time ago and thinking that joint tenancy was similar, but it isn't. Now, one of the ways we know that is just by applying basic real property concepts. Joint tenancy requires 4 unities of interest, title, time, and possession. And to argue, as the appellants do, that there could be equal but separate interests in this one estate is inconsistent with the definition of joint tenancy. It is one estate, not 2 estates comprised of equal separate interests. There's a way that we have in California to do that. We can have common ownership in one property without having joint ownership, and that's tenancy in common. And so if spouses wanted to hold property in common to one asset and have 50% separate for one spouse and 50% separate to the other spouse, they could take title that way as husband and wife, as tenants in common. But here, in the question that's presented, it's joint tenancy, it's held jointly, it's one estate. And to argue that there's two estates is just inconsistent with joint tenancy. Also, taking title in joint tenancy is not a transmutation. And what appellants are arguing is that when spouses took title to this asset that they acquired during marriage, that they've impliedly agreed to have it separate, that they've impliedly created an exception to Family Code Section 760. But at least as to transactions that are happening after 1985 or starting January 1, 1985, we have a rule on that, and it requires an express written declaration, something in writing, signed by the adversely affected spouse that says, I am changing my community interest to separate. We did away with inferences and oral agreements and understandings to characterize property in 1985. But that's what they're arguing. And as Justice Liu pointed out, who even knows what this means? What spouse thinks, oh, gee, if I'm going to take this as joint tenancy, I'm certainly creating equal separate interests here instead of taking it another form. Nobody knows that. Many lawyers don't even think about that. And that's why in 2581B, there's a policy statement saying we're creating this super presumption for divorces, for sure, that applies, but it's a super presumption in 2581 when spouses take title in joint form, such as joint tenancy. It is community, and they wanted a clear set of rules because they recognized the confusion that's been created. Now, there is an anomaly in 2581 that appellants really have not grappled with, which 2581 does create this super presumption. It's something consistent with, but beyond what 760 says. 760 can be rebutted by whatever evidence would show the existence of a statutory exception to property acquired during marriage being separate. 2581 says there has to be clear and convincing evidence in writing to overcome the presumption of community property when spouses take title in joint form to an asset during marriage. Now, certainly, and I acknowledge that only applies during marriage because that's what the statute says. And appellants in their brief said, well, we recognize that. And so if there is joint tenancy property, that will be community only in a divorce. But outside of that context, it would be separate. And that makes no sense. We can't have one asset that has its character as separate, and then when we're in a family court dividing their community estate, it just magically transforms to community. If that were true, we would just disregard and undo our complete system of community property. It would defeat it. And so even though 2581 only applies in a divorce, 760 and 852 apply at all times. Now, the Valli decision doesn't help them. And in Valli, we had a life insurance policy that Frankie Valli acquired during his lifetime, during the marriage with community property, and he named his wife Randy as the owner and beneficiary of that policy. And this court used 760 to characterize it over Miss Valli's claim that it was separate. She said it was put in my name and therefore it's separate, and arguing that he had demonstrated some kind of intent to make it separate by doing that. But this court said no, it didn't. And so certainly in Valli, we have this outcome that titling an asset by a spouse solely in the name of one spouse did not create separate property. Then how could we have a situation where spouses title their property jointly that creates separate property? That doesn't make any sense. Now, there was a discussion, really an exception, I guess, in the opinion about creditors' rights, and that was the proper thing to do. This court should only address issues that are before it and avoid making decisions on ones that weren't. And in Valli, there was no question of a creditor. It was a dispute between husband and wife as to the character of an asset during a divorce case. And so there was no creditor involved. And in Brooks and Robinson, there was a creditor involved. And in an overruling at least part of that case, the Valli court acknowledged that we weren't going to extend this rule elsewhere. And again, that's just being discreet, and that's what should be done. And in Valli, there's also a bit of a difference because there was an asset that was titled in one spouse's name, just like Brooks and Robinson, a house titled in one party's name. There could be confusion to a creditor. The spouse who holds title could end up selling that without consent of the other spouse, and there could be confusion with a creditor. And that's, in that particular situation, makes sense to think about the form of title that was selected and how a creditor could be impacted by a unilateral act of one spouse. But in joint tenancy, the creditor could not be confused. The title is held jointly. Both are on title. One cannot confer title without consent of the other. They both have to be on the deed granting it to do that. Anyone, any creditor, any purchaser would know this is community more than they would ever think that it's separate because it's held jointly by husband and wife. So there's no risk of confusion as to joint tenancy. And even if a creditor were confused, or really we're talking about purchasers, third-party bona fide purchasers, buying property from one spouse, they're protected under Family Code Section 1102. If they're a bona fide purchaser for value and they didn't have knowledge of the marital relationship, they can acquire clean title from one spouse, even though it was community and the other spouse didn't consent to the transaction. We've already covered that. So by 1102, so we don't have to do that. Now, finally, I want to talk about the old rule, because there was a property here that may have been acquired before 1985. The record was not that clear to me, but just to be careful, the court should address that. Now, before 1985, we had transmutations occurring by oral agreement, inferences, and understandings, and that led to a lot of trouble, and that's why we did away with it. But back then, there is a line of cases that created a rebuttable presumption that acquiring title to property by spouses during marriage in joint tenancy was separate. And for better or worse, that's what that line of cases say, but it was a weak presumption that could be overcome by evidence of intent, inferences, understandings, oral statements that they intended it to be community. And certainly, as one court noted, I think it was Hal, the fact that they decided to take title to property jointly is pretty good evidence that they wanted it to be community. So even under the pre-1985 rules, if that were to apply to any of the property here, it's not clear. It's not an automatic, it's separate. It's a weak presumption that could be rebutted. And again, I think that whole line of case law is kind of gotten off the rails in looking at this as more of a tenancy by entirety than by joint tenancy, because spouses, yes.
And I just, on this last point you make about the pre-1985 case law, I'm a little bit confused about your view of the interaction of the sort of the starting presumption, which I think you can read the decision in Ciberel, which we've already discussed earlier, to embody, which is that taking title in joint tenancy is by itself sort of sufficient to create a presumption that the couple intended to hold the property not as community but as separate property. And then I just understood you to say that sort of the opposite, which is that holding title as joint tenants would be sufficient to rebut that inference because it suggests that the couple was actually perfectly content to hold the property as community property. And I'm not sure how to reconcile those two.
Well, it is hard, and I think it's kind of, the history is a mess, and if we trace it back to that Sibrel decision, they're looking at Family Code Section 750, which says that spouses may hold property as joint tenants, as tenants in common, as community, or as community with right of survivorship, and that was misread as meaning that it has to be one or the other. And so if it's joint tenancy, it cannot be community property. And that was an incorrect reading or application of that statute, because these are just examples of the forms of title that could be held, not characterization. So I think that was the mistake. And so as that rule had evolved and been repeated in other cases, the courts had made clear that this presumption that was court made could be easily rebutted by evidence of intent. And I do believe it was the Howell, I'm mistaking it, but there is a decision that I noted in my brief that mentioned that one of the ways that could rebut this presumption is to show the fact that they took it title jointly. Now, I understand that's a circular argument, but that's what the case said. So like I say, I think it was in a misread of a statute 100 years ago that then got repeated multiple times and was attempted to be softened over and over again. And finally, it was done away with 852 and then with 2581, making it clear that this history of really misunderstanding how joint tenancy worked has caused a lot of problems for people, and we wanted to have a clear system. And so that's about as clear as I can think of it.
Mr. Melcher, thank you. Your time has expired.